So you might be wondering, well, what mistakes could possibly be in a contract that could throw things awry? Many, and they're avoidable. One of the most common ones is not getting the names right on the contract. And believe it or not, it's very important. So you can't use nicknames. If your name is James, you can't use Jimmy or Jim, for example. If your surname is a double-barreled surname with a hyphen, but everyone just uses the first part, that's not good enough. Whatever's on your Medicare card isn't necessarily what's on your passport. So it really needs to have your legal name on the contract. And so that's important. That's an avoidable mistake. Another avoidable mistake is missing deadlines. All right. So failing to have your building and pest inspection report in by the deadline is a common one. The buyer may lose their deposit if deadlines are not met. That's enough reason to make sure you meet your deadlines, isn't it? Not including chattels and fixtures in the contract, just assuming that the shelves in the garage are going to stay. Just assuming, don't assume. Look, it happens more often than we'd like. Sometimes the seller will take the dishwasher with them and you assumed that it was a fixture, whereas it can be unscrewed and unplugged and wheeled away or shimmied away. But just make things clear. If you expect them to be there when you get your keys, make it clear in the contract. Ignoring the sunset clause is another one. Misunderstanding the cooling off period, not realizing the cooling off period exists, for one. Failing to act within the cooling off period. Misinterpreting the length of the cooling off period. So understanding that, because you may be expecting you can terminate under the cooling off period and you missed it because it's 5:15 and you had to have your cooling off period ended at 5 p.m., for example. Okay, next page. More avoidable contract mistakes. Overlooking the finance contingencies, not including a finance clause in the contract. Now, as we said about the contract before, if you don't have each one of these lines, this one, and this one with information in it, then you'll find that you've not included the finance condition in the contract. There needs to be information on each one of those lines. Failing to seek legal advice and signing the contract without legal review, misinterpreting the jargon, overlooking important things. Wow, you might get unfavorable contract terms, or it could actually be a lot worse than that. So you need to always make sure that you either understand precisely what's in the contract or that you seek legal advice. And my advice to you is always seek legal advice. You know, there are conveyancers now I'm sounding like I'm really old. Go to a conveyancer and they'll say, this is our set fee. And in that, we will peruse 3 contracts for you. Okay, but still the same amount. So why not? Disregarding special conditions, failing to specify required repairs or not including conditions for anything. We talked about the special conditions in a previous video. And so not paying attention to the ones that are already in the contract or not including ones that you should have had in the contract to protect you and your interests. Misinterpreting the terms of sale. So misunderstanding the settlement date. Okay, so you thought that you were moving in on this date and that was the unconditional date. You got confused, or getting confused about the deposit, overlooking the current cooling off period. So misunderstanding the inclusions and exclusions, and make sure we understand the terms of sale. Failing to include the annexures. Remember that contract we showed you earlier had annexures in it. Making sure that that information is included in the contract. If in doubt, obviously your conveyancer is your best friend in this situation, clearly. Please don't ask me about contracts when we have our coaching call. Not my job, because I don't want to misguide you in the slightest. That's what they're for. I can give you general information, but that's all. Overlooking title issues, okay? Not verifying the property's title. We talked about that before. When you open up a contract and you're looking at the front page of that contract the second page, and we're looking at the title reference number here, the sales agent may have put that incorrectly, in which case you've just bought somebody else's land. It's not that stupid. It's not that funny. Okay? Let me read what's written here. Not verifying the property's title, overlooking easements and encumbrances, ignoring boundary disputes, failing to check for outstanding mortgages or liens. Problems cause legal disputes over property ownership. Right. There's more avoidable contract mistakes. Incorrect deposit handling. Okay. So not paying the deposit on time and paying the wrong deposit amount. Failing to provide proof of payment and not understanding the refund conditions. Okay. So yeah, I mean, you might not get all your deposit back. Just understand that. Inadequate insurance coverage. Okay. Did you know that the day after you sign the contract, you have until 5 p.m. to take out insurance on the property that you don't own yet, whether that be a block of land or a house or a unit. If something happens and there's an insurance claim that needs to be processed, if you're not insured, that's a really big problem for you. I'm talking about if it's a block of land and there's a tree on your block of land, and in Cyclone Alfred, for example, that tree fell on and crushed someone's house and you don't have insurance on that block of land, that's going to be a legal situation for you. What happens if it's not a block of land, it's a house that you've just bought. The seller's still living in the house, but it floods or it burns down or a tree falls on it or a car runs into the fence. There's many reasons why you need your own insurance. And I think we definitely covered this in another module. I think it's covered in module 9 completely. But yes, you are responsible for the property 5 p.m. the business day after you sign the contract. Unclear occupancy terms that are not made clear. You haven't understood them in the contract. That means that you thought you could move in and you can't, or you thought the tenants were moving out and they're not, or you thought the sellers were not still going to be there when you picked up the keys. Ignoring maintenance responsibilities. Okay, so the seller didn't maintain the pool. The pool went green and you came in to move into the house and this pool is like soup. Well, that's property, because if there was a special condition in the contract that the seller was supposed to maintain that pool and not let it turn into green soup before you picked up the keys, that's a problem. Miscommunication between parties. The last one here on this page is not informing the seller of your finance approval, failing to communicate inspection results. Okay. If you weren't happy with the building and pest inspection result, but you didn't tell them and it's too late, the date's passed, you can't get out of the contract. Okay. So the building is unstable and almost going to fall down and you have missed some dates and not sent that building and pest inspection report to the seller by the due date. Ouch. That's a legal situation that you don't want to be in. Okay, so they are the avoidable contract mistakes. I'm highlighting these for you so that you treat contracts with the care and respect that they deserve, and you involve your conveyancer whenever you have a bit of an eyelid flutter about, what does this mean? I don't understand. Okay, nice to see you again. I'll see you in another video, no doubt, very shortly.